This is the panel that is funded by the university. And in this panel, what we're going to discuss is basically how EU cyber policy, which has progressively emerged as a distinct field of EU law, has been transformed in recent years, which is exemplified through the adoption of various cyber concentrated acts, such as the Cyber Resilience Act, the Cyber Solidarity Act, the Cybersecurity Act, or the reform of the NIS Directive. We also, in this transformation, it's not only cyber-concentrated acts that have been adopted, but it's very evident that other acts broadly part of the EU digital policy also contain provisions on cybersecurity. For example, the AI Act is a key example in this context. So within this panel, we're going to address a series of questions concerning this evolution of EU cybersecurity law in recent years and explore various issues regarding its coherence, the benefits that this renewed legal framework has, and any challenges in implementation, both from an academic perspective but also from a practitioner's perspective. So to explore these matters, we have compiled a stellar panel of experts from various standpoints. Our first panelist is Suzanne Usselder, who is a PhD candidate at Tilburg University, working on the interplay between cybersecurity and data protection law. The next presentation will be from Laura Brodal, of counsel in the EU regulatory practice of Wilson, Sonsini, Goodrich, and Rosati. The third presentation will be given by Dr. Marco Almada, who is a postdoctoral researcher within the chair of cyber policy at the University of Luxembourg. And last but certainly not least, Professor Elaine Fahey is a professor of EU law at City St. John's University of London. So the format of this panel will be as follows. Each speaker will have about 7 minutes for their initial contribution, highlighting some key points with regards to the topic of this panel. And this will be followed by an interactive discussion of approximately, hopefully, 30 to 40 minutes between the speakers. And of course, we hope the participation of the audience will be instrumental here as well. Without further ado, and in the interest of time, I give the floor to our first presenter. Suzanne, the floor is yours.
Okay. Thank you, Niovi, for organizing this very timely and interesting panel. In recent years, EU cybersecurity law really has undergone a massive transformation, with new legislation being proposed and adopted in quick succession. And in the age where almost every aspect of our daily life is kind of increasingly relying on digital technologies, the importance and significance of cybersecurity has also surged to unprecedented levels. Oh, I think I have to be a bit closer. So the early origins of the emergence of cybersecurity law in the EU can actually be traced back to the 1990s already. And initially it was addressed together with data protection law. But over time they developed into two separate domains, with cybersecurity being formally established as its own policy domain in 2013. The first legally binding cybersecurity law provisions can also be found in this area of data protection, privacy, and telecommunications law. And then throughout the mid-1990s and the early 2000s, cybersecurity concerns started to proceeded to permeate into EU policy documents. And at this time, cybersecurity was primarily seen as an economic concern, so tied to the internal market. And with regards to adopting legally binding cybersecurity law, the EU was a relative latecomer. So we find the first actual cybersecurity law in the EU in 2016, and this was a very big milestone for the EU. So in 2016, the NIS Directive was adopted, which is the first horizontal cybersecurity law. And the NIS Directive stands for Network and Information Security Directive. And this really represents a step change in the EU's regulatory approach to cybersecurity, as it moves away from a relative hands-off approach, relying on voluntary mechanisms and soft law, to really towards obligation. And since then, cybersecurity is slowly but steadily becoming the main subject matter of a slew of regulatory initiatives, which regulate different facets of cybersecurity, but also and rely on a whole range of regulatory techniques. For instance, we have the Cybersecurity Act, which provides the permanent mandate for ENISA and also lays down the foundations for the EU cybersecurity certification framework. And the period that followed the 2020 cybersecurity strategy is one of very accelerating regulatory speed and intensity. Things really start to kick off here, and we get a massive wave of cybersecurity legislation. So we get the Cyber Resilience Act, which is rooted in the new legislative framework and introduced the first set of horizontal requirements for products with digital elements. Then we also have the Cyber Solidarity Act, which aims to enhance the EU's collective cybersecurity crisis management preparedness and is very closely connected to the EU's policy on cyber defense. So now we have the Cybersecurity Act, the Cyber Resilience Act, the Cyber Solidarity Act. We also have the Cybersecurity Regulation, and we're slowly starting to run out of names to call cybersecurity regulation or acronyms. So then we have DORA, and DORA is the Digital Operational Resilience Act, and this is one of the examples of sector-specific EU cybersecurity legislation, and by far not the only one. So DORA is for the financial sector, but we also have this for the energy sector and many other sectors, and now there's some rumblings about something like this for health as well. And DORA lays down extremely detailed and granular cybersecurity obligations. So interestingly, around this time, we can also see a stark change in how EU cybersecurity law is approached. In the early days of EU cybersecurity law, obligations were rather high level and principle-based, with requirements such as implement appropriate technical and organizational measures. And over the years, they're becoming more and more detailed and granular, and also increasingly supplemented by implementing acts and delegated acts. So the first NIS Directive just had this requirement of adopting appropriate and proportionate technical and organizational security measures, and NIS2 Directive supplements this with an implementing regulation giving quite a lot of detail regarding the technological and methodological requirements for such cybersecurity requirements. And DORA is another prime example of this. So not only are the provisions in DORA itself extremely detailed, prescriptive, and granular, they're also further supplemented by various delegated acts, regulatory technical standards, implementing technical standards, and implementing regulations. And this leaves little to the imaginations. DORA is really a very massive, long law that kind of tells you step by step exactly what to do. And with this trend of increasing reliance on implementing and delegating acts, we also see a bit of a shift in competence that is being delegated towards the European Commission, and thereby also increasing the legislative power of the Commission. So where are we now, and what should EU cybersecurity law move into next? Currently, EU cybersecurity law is best described as a rather eclectic patchwork. It's an extremely complex and overpopulated legal landscape consisting of a plethora of horizontal and sectoral legal instruments. And they target various aspects of cybersecurity, ranging from critical infrastructure protection, product legislation, cyber defense, cyber diplomacy, certification, and much more. And with this multitude of instruments, there's also the risk of overlapping requirements, duplication of measures, legal uncertainty, and fragmentation. And this can also very clearly be seen when it comes to notification and reporting requirements for cybersecurity incidents. And the administrative burden for entities subject to multiple regulatory instruments is very high, and there are open questions on how the different instruments, as well as the bodies and corporations established by all these different pieces of legislation, actually fit together and work together. So even though having good cybersecurity obligations is crucial for cyber resilience and cybersecurity, it's essential to ensure that the regulatory landscape is not needlessly difficult or burdensome to navigate. So after this period of extreme regulatory speed and expansion, it's time for a new phase in the development of EU cybersecurity law, which should focus on streamlining and simplifying this highly complex domain. Otherwise, we risk not seeing the forest through all the different trees that we have. And a first step for streamlining could be this area of notification and reporting requirements. And it is very important that this next phase of streamlining also focuses on smoothing out the interplay between data protection law and cybersecurity law with an eye towards reconciliation between the two. So although data protection law and cybersecurity law are very closely connected and have a common start, the potential risks to fundamental rights of pursuing cybersecurity should not be overlooked. Importantly, the manner in which cybersecurity is pursued in practice may simultaneously pose risks to data protection. So the complementarity and synergies between data protection and cybersecurity that are expressed at legislative level may not hold at the level of technological implementation. And even though cybersecurity legislation calls out for carrying out its obligations in accordance with data protection law, the question remains how this ought to be done. And this is a question that requires urgent attention and should also be really taken into account so that we don't just streamline and simplify between the cybersecurity legal instruments, but also between cybersecurity legal instruments and touching upon other domains such as data protection. Thank you.
Thank you so much, Susanne. I fully agree with your comments about the creation of this eclectic patchwork. The key question now for practitioners is how difficult is it to navigate when providing advice to all these entities which are subject to the requirements on cybersecurity? Laura, what is your view?
Thank you. And I have a slide that goes with my talk. If we can pull that up while I'm talking, that would be marvelous. I like to represent the main message that I try to give people in an image, and so I want to start with an image. If you ask me what is cybersecurity from a practical point of view, I will point to this. It's basically companies will fall into one or two of these characters. Either they are quite digital in nature or they have been regulated for a long time. So think of cybersecurity software providers, telcos, financial industry, healthcare, they're Buzz Lightyear. For them, the idea is, okay, this has existed for a long time. Maybe we need to document things more, but we can handle this. This is not a Copernican revolution. And then you have those for whom this is a big change. Typically, they're more traditional sectors, or they have, since the rise of digital supply chains or digital products, they've been facing more and more the digital aspect of their products and services. And now that also comes with the idea of cybersecurity by design, whether or not that's a service or a product. And that's what we see in these laws. If you take a step back and you look at the framework that the EU has created, you can basically divide it into, there are certain services that we now consider very important to society and connect all of us, and so we're also expecting you to increase the protection, because if those services go down, that disrupts our society. And a lot of the digital infrastructure, a lot of the sectors that were not yet in that space now have to deal with a higher standard. Often that comes with documenting what they already have, but also dealing with new legal obligations that they weren't used to. For them, they're woody. They do still think, oh, there's quite a high threshold that we now have to comply with that we maybe historically didn't do. Then there's the other aspect of it, which is product safety and product liability, which is an EU favorite. We've been doing that for a long time, whether it's toys, medical devices, you think of it. Now that the EU sees that a lot of what we put out in the market and faces a consumer is digital, they're saying we also want cybersecurity by design. If you want that product to enter the EU, this is now something you have to comply with. And depending on the harm that that product can cause to a consumer, we have different levels of cybersecurity compliance that we're going to ask from you. And I would say those companies in the hardware space, unless they have historically been active in cybersecurity, for them it's a step up. They're woody. They're having to think, do we need to redesign what we already have? Do we need to take that into account for our new product line? So they're maybe not as happy about it. The other sectors that I mentioned, think of healthcare, think of telcos, think of finance. When they look at the sector-specific laws, they help design them. So for them, it's not a huge revolution. They think, well, we do a gap analysis, we document, we explain why we do what we do, but if we were not already complying with these rules, we would be losing money. If the finance sector didn't already comply with the things that are outlined as principles in DORA, that would cause issues for them. So while they're facing new legal obligations, because these laws don't only require cybersecurity compliance, they also come with things like personal liability for management, new definitions of incident notification. They do have to deal with those things, but when it comes to the cybersecurity compliance element, you'll fall into one of these two buckets. So if you go home and you think, what does it mean for practice? Think of Woody and Buzz. Now, I've worked, that's the third time I use historically, and it's gonna make me sound old. I've worked for most of my career for two types of sectors, finance and tech, so hardware, software. So I can say that when I look at DORA, why am I saying the cybersecurity compliance aspect isn't that new? Is because this is mainly reflecting EBA guidelines that have been around for a long time. Part of outsourcing obligations on financial institutions has been, if you outsource and there are these types of risks, you need to account for them, and you need to have, for example, due diligence, you need to have business continuity plans, you need to have contractual obligations on your service providers. So for them, this isn't entirely new. And what they typically look at as being new is when certain things are more prescriptive, and that is coming through these delegated acts under DORA. So I would say for DORA, this is just an evolution of the sector, but not a main change for them. What they do welcome is that the requirements are principle-based. And I'm sorry if this sounds as if I'm contradicting Susanna, I'm not, is that yes, if you're not in that space on a day-to-day basis, it might look very prescriptive. But again, in the financial sector, that's always been like that. If you look at the guidelines from the EBA, if you look at instructions that financial authorities have given after audits of financial institutions, this is quite similar. But now it's binding for everyone. And it's meant to also ensure that not only the existing players, but the new ones, the crypto providers and others that are entering the space, that they comply with this high standard, that they don't find ways to create loopholes that would then cause the entire financial industry to be at risk. To give you an example of what I mean with principle-based, there's obligations in there regarding authentication controls. That is, to me, a principle, because it is making sure that access, whoever accesses the service, is appropriate to the risk. What would be prescriptive is to say passkeys are required. So to prescribe a specific measure. That wouldn't work by default, because the nature of cybersecurity is you see a threat, you develop something to address it. You predict the threat, you develop something to stop it. So it's evolving by nature. And that's why even though they could be seen as prescriptive, they're still principle-based, and that's something that I see in practice cybersecurity professionals have welcomed. In other instances, they have said, okay, this formulation really doesn't work in practice. I'm not sure where that came from, but I don't know how we're supposed to interpret that. So it's definitely an exercise that you do with your legal and your technical experts together. If there's an area where I would say, in practice, there's more hesitation, it's the implementation of the Cyber Resilience Act. This is this product liability law for hardware and software digital components, or products with digital components. This is basically cybersecurity by design for those types of products that want to enter the EU. Mm-hmm. And there's a lot of questions about, okay, but what is the definition of a product that falls within the scope? How are we meant to interpret these different buckets that you've defined? Where do we fall? We do these different types of activities. They don't entirely match this definition. From a technical perspective, we could say this is segregated, this is not logically segregated. So I do see the most friction in implementation coming with preparing for the Cyber Resilience Act. And then if there's one where I would give you something to think about is across all of these cybersecurity laws, there has been a rethinking of incident management. Because the reality is that an incident can now trigger these various laws notification obligations. And you cannot segregate your approach to them. You can't say there's one incident, oh, we have 5 different teams working on them. That's not how it works. Those incidents have existed in the past. Maybe they've taken a different form today. Maybe the attack surface has increased, so there's more of them. But companies are now learning to involve more people in how they manage the incident. They're educating people about there are events that now also come with notification obligations, whereas in the past that wasn't the case. And they're more prepared in the sense that if it's this complex to handle one incident, we need to make sure that staff know what to do. So I've seen a huge increase in dry runs, which is a kindness you can do to your staff. Because the worst thing you can have in practice is facing something that you're now fully liable for. You have to talk to various authorities and you have no clue what to do. So do a kindness to your employees and your staff, do a dry run, walk them through it, make sure they know who to talk to, who's gonna be managing things, where to go. And I think that that would be my main recommendation when thinking about cybersecurity laws in an organization is you're either Woody or Buzz and do your staff a kindness and think about organizing a dry run or a conversation about how to now manage an incident. Thank you.
Thank you so much, Laura. I'm sure the audience will have difficulty forgetting the parallel. So in this patchwork of legal instruments, it's not only those instruments that are concentrated on cybersecurity, but there is also the tendency to find provisions on cybersecurity here and there in other acts, and that also adds to the complexity of this legal framework. A key example in this context is the AI Act, and overall one of the issues that artificial intelligence creates is that AI is not only a way to increase cybersecurity, but also a threat to cybersecurity. Marco, what are your views on this interplay between AI and cybersecurity?
Well, thank you, Niovi. It's good to follow up here on Suzanne and Laura, because now they have set up all the landscape, and I will have the opportunity to zoom in into this aspect and to start with this point. Okay, so why do we care about artificial intelligence in this particular context? Just like Laura showed us about cybersecurity being everywhere, that's also the case on artificial intelligence. Probably most of the panels you followed during these 3 days, you're going to see something about AI, about risks, and cybersecurity, as one might expect, is no exception to that. And as Niovi anticipated, we have this dual aspect, because on the one hand, there is much talk about the potential of artificial intelligence tools to support cybersecurity. For example, for automatically developing code that avoids certain issues that emerge through human error, or to help analyze automatically event logs to detect potential incidents and so on. But at the same time, you have artificial intelligence being a risk, creating cybersecurity risks for 2 reasons. On the one hand, because those same technical capabilities that make artificial intelligence potentially useful for defenders can also be leveraged by attackers. You might use, for example, automated code generation to serially create various tools that try to find exploits in a certain software system, and then if one of them works, the cost of trying basically to brute force vulnerabilities become much lower. So this is one thing where AI might facilitate the life of attackers. But on the other hand, you also have artificial intelligence systems as sites for vulnerability. That is, you have to look at any artificial intelligence that is deployed in a particular context as a potential. It is a computer system, and as any computer system, it has its vulnerabilities, which an organization might need to address through, and that might be addressed by technical measures, looking at how you develop those AI systems, or organizational measures regarding who has access to them, what are the procedures for integrating those AI systems within your business or your organization more generally. And in facing this, we have not just those measures that are considered on the cybersecurity specific laws, which have now included provisions. For example, in the Cyber Resilience Act, you do have a provision specific to high-risk AI systems as defined on the AI Act. And that provision in turn refers to a requirement that is in the AI Act that high-risk AI systems must have an appropriate level of cybersecurity. We can find other examples in sector-specific, but focusing on this interplay between the Cyber Resilience Act and the AI Act will be useful to clarify certain things. The first one of them is that, as Suzanne anticipated, we have here a tension between two of the aspects that Suzanne has discussed earlier on. And the one, which is, she has mentioned two things that are both true, which are that you have more specific laws. In this case, you have something that requires not just you must have secure, but you have to meet certain thresholds in the very design of an artificial intelligence system that falls into the high-risk category. But on the other hand, you have it as a terminology of appropriate level. In nowhere in the AI Act, you're going to find the definition of appropriate. Then the Cyber Resilience Act, you have provision that says that a high-risk AI system that's covered by the Cyber Resilience Act, if it complies with the requirements therein, it is considered to meet the appropriate cybersecurity level. But still, understanding those cybersecurity risks, especially given that artificial intelligence technologies can be used everywhere, is somewhat vague, and this entails certain means for further specification. We have delegated regulations, implementing acts that might provide further detail. You have non-binding tools such as ranging from harmonized technical standards, which will likely come in the next few years, as required by the AI Act, for example. But you also have international standards with non-binding value that still provide information, codes of practice from sector-specific. So you have various sources of information that try and provide a bit more substance to those requirements. And one challenge they face is the uncertainty surrounding those technologies, because, very few people would imagine, even 10 years ago, that we would be able to do as much with AI as we can today. And that creates the questions, when you're designing law, when you're designing requirements, what will AI be able to do in 5-10 years from now, once the legislative procedure is going, once things are underway? But on the other hand, it makes us not see also the risks that are involved. We don't know vulnerabilities. And even the current studies of the state of the art on the technical side of AI cybersecurity tend to highlight that there are quite a few attacks that we don't really know how to address them. So this creates a temptation both at the lawmaking side and at the side of organizations that are complying to go with hype, that is, look at what is being promised that AI can do or might do in the future, even though we might not necessarily always have grounding. And this in turn creates certain difficulties, because some of the fixes, in particular when we're talking about AI, sometimes you have requirements such as security by design, in which you are embedding certain security practices within AI systems, developing them in a certain way. But when we are dealing with large-scale AI technologies, adapting those security measures in case that they turn out to be inadequate might take a long time, long effort once they're put into place. So it might be even the case that something that makes your AI system secure today can become a source of vulnerability tomorrow. Or conversely, you might also have the case where things that we expect to be big problems today turn out not to be so big, because somebody has come with a development that makes them not sensitive about certain aspects. For example, there are always, if you accompany the literature on artificial intelligence technologies, there are always talks about, this is an intrinsic limit to AI, and then a few years later, somebody comes up with a technique that managed to combine data processing capabilities and does something that we thought impossible. Just like large language models revolutionized the field of natural language processing. So after presenting this overview that in short means that we don't know much about how AI technologies are, and we don't know much about what threats they can create on from a cybersecurity perspective, and mainly even the threats that are already known can be pretty difficult to pin down what are the proper responses to them. Should that be reflected on technical perspective? Should that be reflected on organizational measures? Do certain kinds of vulnerabilities, such as the possibility of extracting information from the prompts of a large language model, mean that AI might not be suitable for certain use cases? And the answers to those questions are pretty mobile. And so to wrap up with this, what we can take from this in practice is that these tensions are not likely to go anywhere anytime soon. So there is a need to develop within organizations that are, both the organizations that are enforcing the law and the organizations that are compliant with its requirements, to develop this awareness of whether many claims about what AI can and cannot do should not be taken at face value and should be investigated more deeply. And for that, it is necessary to develop capabilities. And here, it is something that's not just relevant for private actors, but also needs to be taken at the state level and has to some extent, because you see that cybersecurity policy recently has not just been the imposition of laws, but it has also an increasing focus on the development of capabilities, trying to create shared pools of resources among EU member states and fostering public-private cooperation, and that's going to be essential for tackling those challenges. So I don't have a message of hope, but a message that we need to be careful not to overblow the problems, but also not to overblow the solutions, and tread carefully here when applying all those requirements we need for the artificial intelligence domain. Thank you.
Thank you so much, Marco, for this intervention. It seems that the complex landscape becomes even more complex when looking into the different technologies that may be used to assist in enhancing cybersecurity, because they may become a threat in the future. Elaine, in your view, this evolution of the EU cybersecurity framework in recent years, how does it fit in a broader global context, for instance, when looking into similar initiatives and similar concerns at US level? And the PowerPoint presentation, please, could be up. Thank you.
Coming? It's coming?
I've sent it. It should be on.
Thank you so much, Niovia. I'd be really grateful for the PowerPoint slides, because I'm not as techy. I'd love to be able to remember everything.
They're not working? Yes, that's the second one.
I have it there on the slide.
No. I gave the slides.
Oh, okay. Oh, thank you so much. That's amazing. Thank you. So I'm really grateful to Niobe for organising this and the Luxembourg chair, because I think it's interesting to be part of this, because cybersecurity is. I'm interested in this from the transnational level and from the perspective of global governance. And a paper that I'm going to just very briefly, Niobe told me to be very quick. I wrote this last summer, and it was published last autumn. And there's so many interesting things happening in recent times, particularly the Cyber Solidarity Act and developments at UN level. There's other panels on this that you should definitely go to if you're interested in cyber issues. But from my perspective, I do a lot of transatlantic relations, and you may say, well, that's a strange focus for this now. But across many administrations, it's quite an interesting way to focus upon collaboration of two of of the world's largest global governance actors, even if they don't cooperate. How do I change the slides? Do I make hand gestures? Oh, thank you very much. So, if you're interested, sorry, I know I'm in a room of tech wizards, but I don't know if you can anticipate my thoughts or something. Although Google and DeepMind are with us everywhere, I know. So the paper is in the Journal of European Integration, and it's a paper on the evolution of cybersecurity law and on understanding drivers of convergence. And I worked with a lot of political economy people on this, and I had a big battle about the title. I wanted to call it cybersecurity and cybercrime, and I put cyber and security separately, and they said, no, it's all one word. We had a major disagreement. So from a legal perspective, this is not true, which is symbolized to me many of the issues. It's in the European Journal of European Integration. It's open access. You can, will I just do this? No. Thank you very much. So I'm interested in this idea of cyber as a transnational threat, as a policy, and as something that that is a regulatory space, and that there are very significant global actors, and there are many different forms of administrations engaging. And I'm really interested in this case study for the one reason that there are so many differences, but there are so many similarities. And I think people who work in cybersecurity say this as well. You've just heard from Laura, but over long periods of time, there's many, there are many regulatory problems. It's just another regulatory problem to face, if you like. And there's theory and practice divergences. But I was quite struck by how debates in the US 20 years ago mirror concerns today about the sectoral proliferation you've heard from Susanna, and about the, at a technical level, again, that many of you are also interested in, I'm sure, about how this breaks down. Yeah, so and I also was fascinated by how two really, at least until recently, largest democratic and capitalist jurisdictions of the world, the digitization of the contemporary economy, I think is there's more subjects than objects. There's more to regulate, and there are more security concerns. It's a very factual, descriptive, boring statement to make, but from a legal perspective, at national, international level, these issues matter. And you've about 400 definitions of cybersecurity globally, and you have tremendous disagreement on where cybersecurity should go. Should it be in trade agreements? Should it be in partnerships? Should it be in soft law? And again, as I said, the definitional question, is cybersecurity one word? And should you discuss cybercrime and security? Some people say lawyers are obsessed with cybercrime, that's in the past, and we policy tech gurus look to the future. Cybersecurity, I'm really tired of those debates, but they're very real debates, and they go to the nub of the question about the framing of it. I'll do sorry, my waving here. I mean, just very broadly, I think the cyber convergence between the EU and US is an interesting one to study, because they both have similarly changed over time and have addressed very similar risks. So I'm interested in debates as to digital sovereignty and defend forward, and the Internet of Things and international cooperation. You might say that's quite a basket full of verbal stuff to take on board, but this idea of increased protectionism and understanding external threats and understanding regulation by design, where we have more subjects and objects to regulate, I think is a fundamental basic legal question. And international cooperation cannot be ignored. I think it's very, very obscure to consider just EU regulation in its context, because the international dimension to this just proliferates. And although it's very difficult and involves many actors, it's multi-stakeholder, there are very important debates going on, however, particularly at the UN level, as the Digital Compact and cybercrime, that really influence our understanding of these regional and also national debates. So very quickly, I think it's important to say that temporally the US is actually a lot earlier than the EU in terms of its first step in regulation, and it's much more sectoral, and it initially is actually much more hard law oriented, and about 20 years ago became very much market led as the basis for cyber law, and there's very interesting debates about cyber war and so on, about the linguistics of this. But ultimately, the EU and okay. Oh gosh, sorry. Now you've overexcited me. Oh yeah, sorry. Thank you. Yeah, thank you very much. And so, just to say one of the just really briefly that the EU cybersecurity law has a vast array of legal bases, and what's quite scary for me looking at this paper, having not worked on it for a number of months, is how competitiveness as a legal basis emerges in the Cyber Solidarity Act, whereas we've seen the internal market and the common foreign security policy be the key legal basis in the last number of years. So the shift towards rights-based, market-based and defence orientation is a very obscure mix of EU powers, and we see the EU becoming much more market-based in its legal definitions of how to address cybersecurity, but also this proliferation in the Russian aggression and so on as to cyber sanctions, and seeing tremendous amount of work taking place on sectoral developments. Now, there's some fantastic people who are political economy scholars that you should read if you're interested. People like Elena Carapico and her husband Ben Frandt have done really interesting work on private actors being co-opted into European legislation. And I suppose they also, this part of the work on agentification, cybersecurity is very similar to so many fields of law where the EU emerges as this bureaucratization, institutionalization emerges really well over time. But as I said, the subjects and objects emerging, and the Internet of Things in particular being this very clear example of an entity where there are more users and manufacturers to regulate is a very good example. And data protection and fundamental rights become, I think, increasingly complex. If you look at a lot of the, cyber sanctions and so on, and Mark has gone through this in great detail as to AI. So just very briefly, I look at the, I thought it's a good example, just if you can go one forward. Yeah. So, what happened just in the last few months as to the Internet of Things, with the US administration being so proximate to the EU, there's tremendous work going on behind the scenes. The European Parliament Libe Committee was in Washington, D.C. so many times looking at how to influence developments in the Schrems context. But there was the voluntary developments, the vote towards a cyber trust mark in the US in 2023, and very important cyber dialogues generating a mutual recognition agreement necessitation between the two sides, and also an administrative arrangement on safe products, shows, I think, the importance of studying bilateral dialogues, of mutual recognition agreements, however unsuccessful, and the nature of transnational forums. So on the next slide, I have this beautiful table that you can consult if you're looking for a 1-second summary of all of my work, and I haven't had enough coffee today. But I think if over time, you'll see that extraordinary similarity between the EU and US that maybe are just a reminder how over time there prompts, the gaps between sectoral policies, between binding law, between, there are just so many similarities that are quite striking. So I suppose just to conclude that it's important to say that divergences domestically are very important, remember, but they don't bar international cooperation, even across administrations. And I think it's quite useful to be studying UN developments, to be looking at the weakening of EU positions, the difficulty of EU positions, and the Digital Compact in cybercrime developments, how that differs from the Council of Europe. Marco and others have done fantastic work on this, and how cybersecurity by design embedded into systems is something that's a very important development, to see the broadening out of institutionalization and bureaucratization, just like in many contexts. Thank you very much.
Thank you so much, Elaine. It appears that similar questions have prominently arisen also in the US, with some differences and some similarities in the regulatory framework. We have a good 30 minutes for discussion to open the floor also to the audience. Rather than me posing questions that I had prepared in advance, most of which have already been somehow addressed by the panelists, I would like to open the floor to the audience for any questions or comments, and to spark the discussion. Yes, please.
Hello. 1, 2. Okay. Stamatis from European Investment Bank. I want to ask if we can touch upon the procedural aspects and for the enforceability of cybersecurity legislation, especially with the fragmentation of supervisory authorities. We have exactly the same issue with AI Act, with very different market surveillance authorities. So if we draw some parallels from that, would be also useful. Thank you.
Anyone from, maybe to give the opportunity to the panelists to think about those questions, maybe we can collect a few more, if there exist. Yeah, Juraj.
Hello, Juraj Seifert from the European Commission and also a postdoc at Vrije Universiteit Brussels. So the question is for anyone who wants to actually tackle or reply to this. Just wondering what are your views on the initiatives for lawful interception and especially lawful access to encrypted data by law enforcement authorities, and how do they actually can be reconciled or cannot be reconciled with everything you talked about today?
Any other question or comment?
Yeah, quick one. Do you have an update on the EU CS certification scheme?
And yeah, there are.
Hi, I'm Silvia from the Center for Democracy and Technology Europe. I just wanted to pick up on that question, something that we've been also working on. I've realized that the EU law tends to work in silos, and cybersecurity seems to be one of those silos that is never, looked from the comprehensive, taking a comprehensive view on how cybersecurity rules may work together with other key principles of EU law, such as fundamental rights. So going back to that question, do you have any strategies as to how European institutions could break these silos and work in a more comprehensive, overarching way that develops good policy making?
Mm-hmm. And one more, and then I'll give the opportunity to the speakers to respond.
I'm Benfit from law firm Timelex. I have a question more from a legal point of view. If you look at the NIS 2 directive, what does this personal liability mean for board members? Because if you look at the provisions to impose a fine, that fine can be imposed on the NIS 2 entity, but not on the board member itself. So what does this personal liability mean in practice?
Okay, any of the panelists want to answer any of the questions? I think it's fair to give them the opportunity to pick and choose which questions fit better. Yeah, Marco, do you want to
I
start?
would like to add some points on the question about enforcement and the parallels with the Artificial Intelligence Act. And yes, this seems this is a big challenge that we face here, because you have fragmentation not just at the horizontal level, given that you have relied on mechanisms that do not centralize that much. Okay, in both the Cyber Resilience Act and the AI Act, you do have a role at the European level, but there is much that is left at the hands of member states. But so this creates the need for not just for harmonizing the parallels of practice, but also to ensure a uniform level of capabilities, because given that both approaches to AI and cybersecurity, both instruments dealing with AI and cybersecurity require lots of technical knowledge to implementation, and that they interact with not just they don't just require technical knowledge. They also require some very specific kinds of legal knowledge that are not always accessible to organizations. They are accessible to public sector enforcement that already have cybersecurity competencies that have been dealing with that. But the regulated actors, especially given the broadening that Laura has discussed, cybersecurity becomes a much more prominent question for sectors where it was not so big of an issue before. Those actors might not, at least in a first moment, have already the capabilities to deal with that. And if you come to the AI Act, even the enforcement authorities, because you have at least one market surveillance authority, but you have necessarily more than one market surveillance authority per member state, because the AI Act obliges each country to also involve the authorities that are already, for example, involved in market surveillance authorities in certain other products that are covered by the AI Act, or the authorities in the financial sector. So you're going to have lots of bodies at the national EU level talking with different enforcement cultures. And this is one aspect where the partial coordination between the Cyber Resilience Act and the AI Act facilitates things by connecting compliance with the cybersecurity requirement with following the requirements on the Cyber Resilience Act, because there you diminish the differences in enforcement cultures, because you are dealing with authorities that have been all facing the problem of cybersecurity for some time, as opposed to the situation where you have more generally in the AI Act, where you have also where you might have one country where the main efforts of enforcement is led by the Data Protection Authority, versus one where the efforts of enforcement are led by the telecommunications enforcer, versus one where it's a more general product regulator, and so on. And all those different sectors have different practices. So by concentrating the cyber-specific provisions of related to AI within the same body, the same bodies that have relatively similar competences in each member state, you diminish the space of divergence. You have policy differences, of course, but you're at least dealing with actors that are doing the same thing and actors that are already in communication, because while you have a creation of networks and systems, you already have a considerable number of networks connecting member state authorities dealing with cybersecurity, which establish a dialogue that is not present in the AI Act more generally. So even though, what we can draw from that you can draw lessons from that from both acts. For the AI Act more generally, it might be the case that the structure used to connect the enforcers at the cybersecurity domain might be something desirable to implement towards fostering informal and informal mechanisms for communication within member states and beyond member states. And for the cybersecurity domain, there's a need to ensure that even though those other market surveillance authorities might have a say there, that given this privileged position that the Cyber Resilience Act gives to them, that the authorities that are already dealing with cybersecurity factors are likely to play a more active role in enforcement. And in doing so, this might mitigate the conflict that we have, but those authorities would still need to dialogue with other stakeholders, given that the AI Act pursues many other desirable aims, such as transparency, which must be reconciled with cybersecurity at some level. So no clear solution for those tensions, but having communications between those actors is at least a very good starting point.
Thank you so much, Marco. Laura, any points on your side?
Well, I can definitely echo that it's a crowded space, and I like using imagery. So we've all seen these American movies where there's a hostage situation, and then all the law enforcement authorities arrive, and there's the FBI and the police, and they're like, no, we're competent, no, we're competent. It's starting to feel a little bit like that, solely or mainly because there are so many laws that will typically regulate the same product or service, but for a different aspect. And as Marco said, you see that there's a strategy behind how they're dividing enforcement. When it's related to cybersecurity compliance, they try and give it to an authority that has the technical expertise to do that kind of review, and then determine whether or not something is adequate from a technical perspective. But at the same time, you're dealing with industries that are already regulated, such as the financial industry, who are used to dealing with financial supervisory authorities. The same goes for telcos. So for them, it would be quite strange if they now have to do some form of double reporting to different types of entities. So it becomes complex, it becomes crowded, and a lot of it is still in development. Because yes, the laws provide for who is going to enforce each of them, but a lot of the cybersecurity laws have either not been implemented yet at the national level. So if we look at NIS 2, there's more than 10 countries where the law hasn't been adopted yet, so they're still in limbo. Yeah. Cyber Resilience Act isn't up and running yet. And then NIS 2, if we then look at DORA, you're going back to your traditional financial authority. So for them, it's more business as usual, I would say, because you're dealing with an authority you already know. So I would say a lot of that is still in development, and well, I wouldn't be surprised if we see situations like we see in the movies where a lot of authorities show up and say, oh, this is an incident, it's a NIS 2 incident. Oh, but yeah, we also alerted the DPA and they also have questions. And they have to figure it out also for themselves. What would be the most efficient way to collaborate? For example, I've spoken to data protection authorities who've said, well, if there's an active NIS 2 incident, we don't want to get in the way. Because if someone who has actual technical knowledge and who can help the company stop the threat, we don't want to get in a way with an RFI at that point. We might show up later, we might still have questions, but we also need to agree with other authorities what is best at that point for society, for individuals. So they're also figuring it out, collaborating, finding a way to make it work. And then I wanted to add one small point on the lawful interception. That is a very hot topic in practice. I know that a lot of companies have been actively resisting those rules. So for those who don't know what that is, it's, for example, the UK trying to force Apple to build a backdoor so that law enforcement would basically be able to see what goes through the channels, and they can intercept into content and basically not have to go through the provider. They just do that on their own. There's active resistance against that, on whether that is democratic, how that is creating vulnerabilities that would render them out of compliance with these cyber resilience rules. Because if you create a backdoor, yes, the authorities could use it, but there's a lot of very sophisticated threat actors out there who are just waiting for the opportunity to abuse that. So I would say, while a lot of people tend to think, oh, these companies are just out there to monetize their users, when it comes to security, whether it's from a financial perspective to protect themselves, or for some of them an actual ideological point of view of we don't want to allow that to a government, there's resistance against those obligations. Thank you.
I fully agree, Laura, that these backdoors are basically a double-edged sword, and companies can be in between a rock and a hard place. Compliance with the law, but at the same time generating cybersecurity risks. Anyone else who wants to add anything, Susanna?
Yes, I would like to add on the very good points Laura already made regarding lawful interception of encrypted data. And I think indeed what you're already pointing out is that if you make a backdoor, it's not just a backdoor for law enforcement, it's a backdoor for everyone, also for potential malicious actors. And what you might get here is kind of a situation of security versus security, of security in the sense of cybersecurity, making our digital systems and products as safe as possible, versus security of finding terrorist attacks, law enforcement. And I think this is a very interesting dilemma that you also see, for instance, with the CSAM. What does it stand for again? Child sexual abuse images materials. This is also where this dilemma of security versus security arises again. And I think it's very important to remember that a backdoor is backdoor for everyone. So you do bring a lot of risk to also the collective cybersecurity and the collective cyber resilience, which then impacts hospitals and banks and all these other services that we rely on.
And Elaine, any points you want to make on these questions?
Yes, so there was one very interesting question there on the comprehensiveness issue. I can't remember who asked it. I think this is a really important question about, what would a comprehensive cybersecurity law look like, and how do you understand the emergence of, we have, for example, about 8 or 9 data transfer agreements with the US, but no comprehensive law. We have a huge amount of the emerging EU's industrial policy on digital strategic autonomy is everything from, net zero, cloud computing, cyber, and so on, and the CHIPS Act and so on. That's all highly protectionist defensive legislation, all based on the internal market, all based on Article 114 TFEU, and that's a very rich but also very thin legal landscape, depending on your view, or how vulnerable establishing incredible systems or bureaucratization on the basis of a slim architecture. And we live in an era of digital external relations is really important, right? There's an external dimension motivating so much regulation. And it's a complex question about the reach of soft law. Everyone is quite obsessed with digital partnerships now. Trade agreements are old-fashioned and boring, and yet cybersecurity, it seems to pursue this very dominant threat domestically. And so all these are very difficult threads to see what the future of this might be, because there are so many, obviously very concerning enforcement agendas taking place. I think the CSA looks quite frightening, the kind of how to understand the architecture, how this is designed. So yes, I think that's a really important question someone has raised there about, what do comprehensive laws look like? What legal base do they have? How do you accommodate defense, competitiveness, fragmentation of the single market, external relations? Does the EU have those legal bases? Who's going to amend the treaties? Are the treaties the useful place to look? Is industry concerned? Does industry care about this? I mean, most people who work in industry, I suspect, are very, would find this very dull or ridiculous questions. But if you're operating on a thin legal basis framework, you're not operating with any certainty, and you're impaired as to design, as are consumers, enforcement architectures and the state actors. Thank you.
Elaine, I fully agree. I think one of the key problems that cybersecurity law at EU level faces is that the EU treaties do not refer to cybersecurity anyway. So it's always cyber laws at EU level have to piggyback on other legal bases in order to exist, most notably internal market, but also cybersecurity is a transboundary issue, not only because it's cross-border, but also because cybersecurity entails cybersecurity stricto sensu, cyber defense, cyber diplomacy, cyber crime, and all this by default create silos within cybersecurity law, let alone within a broader EU digital policy. So I fully agree that the issues of coherence and fragmentation exist, and the more cyber laws are created, probably the more fragmentation is sustained. But I also think that without a concrete legal basis on cyber security, which I'm not sure this is even a priority in any form of the treaties. It will be, an add-on if there will be a need for treaty reform. I think that we have to tidy up the area first within cybersecurity and then see how it fits with other parts of the EU digital policy. Any other comments? I recall the question also on personal liability. This is fairly new, and this is, if I could say one note on that, it's a fairly novel aspect. And in the past, there have been quite few cases where there has been personal liability, and that criminal liability on behalf of managers or leaders of an organization. I think we have to see how this is going to play out in the future, because on the one hand, it reinforces the enforcement of these legal instruments, which is something very much needed, but at the same time, it may seem a little bit too harsh as an approach. Any other questions, any responses to the comments? Yes, please.
Okay, I want to bring to the attention another empirical aspect from the financial sector and how they let's say, respond to non-financial risk, because sometimes it is viewed more like a product of best banking practices or other soft law. So it's difficult to convince even technical people how they need to attain a certain level of technical safety, let's say. For example, can we have a customer manage, let's say, cryptographic keys? Convincing them that it's highly important to do so is very difficult. I don't know if DORA will change the plane for that.
Well, I'm not a financial institution, so I can't speak for the sector as such, but I do know that regardless of DORA, key management is an active part of discussions, whether you're in the financial sector or not. I would expect that because of the due diligence that you see has now increased on security practices, because encryption is part of already other laws and obligations, that it is now a standard question that they ask when they deal with supply chains. I would say in terms of just key management and how that goes in a negotiation, it's very context dependent. Because if you're looking at a supply chain today, there are so many actors involved. Sometimes it's a matter of first being able to map out all the actors involved and then knowing, okay, who can we actually entrust the key to make sure that we're not creating any risks here. So I can say, yes, it's active part of risk assessment and analysis. The rise of cybersecurity laws has definitely increased focus on it. Not only these laws, already under GDPR, looking at key management, and I would say a lot of the focus of data protection authorities on data transfers has really triggered a focus on key management as well. So will DORA be a fundamental game changer there? I don't think so. Would it need to be? I don't think so. I'm not in a lot of negotiations these days where key management isn't already a part, just because there are data transfers or there are so many actors in the supply chain that a way to manage the risk is encryption, and then the discussion of key management comes up. I hope that addresses your question.
Are there any other questions or comments for this panel? Okay, since we have a few more minutes then, and I'm very happy that we managed to have all the presentations and address queries in this time. I was wondering whether you have any final comments on the future of EU cybersecurity law. What would be something that you think that it's needed, how we can bring more coherence in this field, whether we see already that the latest Protect EU strategy of the Commission contains quite a lot also on cybersecurity, including new legislation that hasn't even implemented yet, so revision of existing legislation. So I was wondering, what are your views on, you have like 2 or 3 points of further improvement or further outlook of EU cybersecurity law. Maybe we should start from the last, if you are ready.
Sure. Yeah, sure. So I suppose my three key, my three issues will be, firstly, the digital external relations law as a priority of the EU to augment the place of it. It seems very lost within other priorities. It's lost with the considering how to engage with stakeholders, with developing countries, with international organizations. I don't find it a very clear agenda, and I think the EU can do a lot more as to its mission statement in digital external relations law and to make it a much more concrete one. I think the multi-stakeholder understanding of cybersecurity is still very complex. I'm interested to hear how business or private companies or regions, in fact, are all understood. There's a massive infrastructure of those involved. Increasingly, the soft law shift to hard law, and it's not clear to me that EU administrative law accountability and transparency regimes have caught up with that. And the third element will be impact assessments. I find risk assessments, impact assessments of EU law making a very depressing study, very banal statements of 2 or 3 sentences that fundamental rights are adhered to. And I think in particularly business and industry needs to probably be a bit more, as civil liberties organizations as well, I think will be a lot more prominent in their opposition to this or how we engage with it. Maybe my fourth one is I'd like to see more litigation in cybersecurity. That's just maybe lawyers create work for other lawyers. I don't mean it in that no other way, but I think that there's there's an absence of case law that looks at these questions, and it's not that they're devoid of legal issues.
Thank you. Following up on Elaine's points of improvement, I will do the opposite of what I did in my talk and zoom out, make a few points on the broader perspective that nonetheless draw from these concerns with artificial intelligence. The first one is that we need to better understand this phenomenon that's going on and appeared in all talks and all of our talks and during the questions, which is how cybersecurity, which was something that was seen as a niche interest, is now something that is deeply embedded in so many sectors, and also how it relates to other forms of security. This is something that, on the scholarly side, we need to gain a better investment, and on the policy side, this means that maybe the discussions that we need to have about the future of cybersecurity are different from the ones we could afford to have when cybersecurity was a niche interest. That is, we probably need to involve more stakeholders, have those discussions at different sites, and that will involve another challenge, which is developing the capabilities, because given that cybersecurity is, let's say, by nature, somewhat dealing with technical aspects, we need to make sure that if we need to have more people involved, and I believe we do because it's a more relevant issue for everyone nowadays, we need to find ways to make that debate more accessible, which means not just developing general literacy on the subject, but also on fostering ways in which organizations that were not previously needed to worry about that much can tap into capabilities for developing those competencies. Will that be through facilitating private actors? Will that be through developing more centralized capabilities? I don't know, but this is a problem that needs to be tackled. And finally, that entails that we will need some mechanisms to incorporate into the law and also in the follow-up instruments, mechanisms to deal with those uncertainties and ensure that course correction can come in due time as we face those challenges.
And I only have one point to make, and it's actually what Elaine just said, is we should ask ourselves, do we need more law? Isn't it more a question of all of these issues could maybe be handled by tort law? You know, it's you do something, or you say you do something, you don't do it, now you're liable for it. You made a risk assessment, you didn't take into account relevant factors, now you're liable for it. You were supposed to assign budget, you didn't assign that budget, you knew what the consequences were, now there's harm, now you're liable for it. I would think, especially because these laws are now developing, if we draw the parallel with GDPR, we now see a lot of how we interpret GDPR because of the court's case law, because of decisions from data protection authorities. That's natural. You know, the GDPR entered into force so many years ago, and now we're in that wave. Maybe we need the same for cybersecurity rather than issuing and prescribing more rules, especially to an industry that is, as I already mentioned, evolving by nature. The speed at which the threats evolve, the speed at which the attack surface evolves is so high. The industry is trying to address that almost in real time sometimes. It's very difficult to then put a very restrictive standard on that.
I will keep it very brief because I think we're nearing the end of time. And a lot of good points have been made already. So I think streamlining is one of the important things that needs to happen, which also ties in of, do we actually need more law? We already have so many actors, bodies, cooperation mechanisms. We need to figure out how they work in practice, how actors can effectively navigate all these different tools that we already have available. And we also see this in the current reform consultation process of the Cybersecurity Act, that simplification is one of the points of on the agenda. And then I think indeed this is it's very much a thing of like, blessed are the lawyers for they are inheriting cybersecurity. I think this is from an article that someone wrote a few years ago, but this is really what we're starting to see. It's like, it's no longer a niche technical issue, but it is now very much a lawyer's issue, and I think jurisprudence from the court would also very much help in this area. Thank you.
Thank you so much. My clock says 9:59. I consider this a success. I thank you very much for your engagement in this early morning and quite on a tough topic that it's not to be the most mainstream for discussion. Now it's very clear that it's not anymore so niche. It becomes more and more mainstream, and we hope to see you in another panel. Thank you so much to everyone.